Hello and welcome to part 2 of the consumer credit presentation. We delivered the first part last week. I should say Chris Kirkblythe, CEO of LBS Legal, did. Some of you may be familiar with Chris. What we've done since then is we've been discussing some of your issues and concerns. We've fielded some questions which we've been emailed throughout the week, and we've picked some of these emails which we think may be of interest to you. So for this presentation, I will be asking on behalf of you, our clients, some of the key issues that were raised over the last week in relation to this subject. So Chris, hello again.
Hello.
Hello. The first email I've got here from Jane. She's a family lawyer. And Jane writes the following. She's concerned that she's having lots of discussions about money with clients as part of the work that she does. And for example, in divorce, where people's personal finances are clearly affected, is she carrying out? The question is she carrying out consumer credit activity? She's quite worried about this.
Okay, well, hello Jane and everybody else. So, what Jane will have to do is go through the same process as really every other solicitor in every other practice area, which unfortunately is not a pleasant process, and it is to go through this document which I have in my hand and which I will be referring to, I suspect, throughout today. And it is part 2 of the a statutory instrument which I referred to in the presentation last week. It's the Financial Services and Markets Act 2000 (brackets Regulated Activities) (brackets Amendment) (brackets number 2) Order 2013. It's a bit of a mouthful, but it is a document that you need to print out and become familiar with. Why? Because it contains the definition of what is and what is not consumer credit activity. So in Jane's case, she's a family lawyer, and she's obviously regularly in face-to-face and on the telephone situations with clients, talking about the client's money and the client's financial affairs. And that will involve a whole range of different discussions. Divorce is usually a time when clients are under financial pressure and when they have all sorts of financial anxieties. You know, for example, how will our joint loans be dealt with? How will my loans just in my name be dealt with? Etc., etc. So these conversations just naturally open up between a family lawyer and their clients. So the sorts of issues that Jane will need to consider is, first of all, is she providing debt counselling advice to her clients? And she will need to look at Article 39E of the 2013 order. And rather than me giving you the full title, I'll refer to it as the 2013 order. I think that might save us a lot of time.
Yeah, it would.
So she'll need to look at Article 39E of that order, and she'll see that the definition of debt counselling is very broad. And really, in general terms, if she's ever entering into a discussion with a client about how that client should go about liquidating a debt of any sort, she is likely to be engaging or carrying on debt counselling. Secondly, she ought to look at providing credit information services, which is in Article 89A. And she'll see that, again, the definition of providing credit information services is very broad. So, for example, if she's talking with a client and the client just happens to mention that they're concerned about their credit rating, if Jane just says to that client, well, the thing to do is to go online and get a copy of your credit report, just that in itself would fall within the Article 89A definition. And in saying that to her client, she would be providing credit information services, and therefore she would be carrying on consumer credit activity. So the answer for Jane is that although she may not realise it, she is or is almost certainly carrying on some consumer credit activity. Another way in which she might be affected is that obviously there's been some changes to the availability of legal aid for family cases, and most clients now are privately paying, and most clients struggle to pay their legal bills. Therefore, rightly, firms are being increasingly creative in the arrangements and accommodations they enter into with their clients. Payment by instalments, for example. The danger there, of course, is that in entering into those sorts of financial accommodations with her clients, Jane may be carrying on a regulated credit or entering into a regulated credit agreement with her clients. The definition that she needs to look at is in Article 60B, and I'll read it to you. It's very, very broad. You may have to bear with me while I flick through my pages. But a credit agreement, if you look at Article 60B(3), means an agreement between an individual. Let me change it and put it into easier terms. Means an agreement between an individual and a solicitor, under which the solicitor provides the individual with credit of any amount, and that's the definition. So it's very, very broad. Now there are some exemptions. And one exemption which is particularly useful you'll find in 60F. If Jane agrees with that client that she won't charge them any interest and that they will pay her fewer than 4 instalments, or 4 or fewer instalments, and that they will pay those instalments in a period of less than 12 months, then that will be exempt. That agreement will be exempt, and it will not be a regulated credit agreement. So that may be a way around that. And something that Jane may need to consider is the interest clauses in her firm's terms of business, because if there's a provision in there that the client will be charged interest, then that exemption wouldn't work. So the general answer is Jane is almost certainly carrying on consumer credit activity. However, that is not a problem, because all of those things that I've described will be incidental and complementary to the legal services which she provides to her clients. So both the incidental test and the complementary test, which I discussed last week, will be easily passed in all of those cases. So Jane is quite entitled to carry on that work under the exempt professional firm regime. What I would be anxious about if I was Jane is the fact that the SRA has proposed to shut down the availability of the exempt professional regime altogether. And therefore, Jane needs, and I mean this could happen as soon as December, Jane ought to be carrying out a regulatory risk assessment of what it would mean for her if she could no longer do those sorts of things that I've mentioned under the exempt professional regime, and instead had to either stop doing them altogether or had to obtain full Financial Conduct Authority authorisation for her firm, with all of the regulatory burden and associated costs. So that's the sort of risk assessment that I would be carrying out right now, and I would be considering all of the commercial and financial implications of what will happen to Jane if the SRA achieves what it wants from that consultation paper. I would also say to Jane that you should be responding to that SRA consultation paper, and you should be saying to the SRA, if you do this, this will hurt me, it will hurt my clients, it will deprive some of my clients of access to justice, it will prevent me from doing all sorts of good for my clients, such as showing them kindness and understanding in relation to their bill, and it's completely unnecessary, and that your firm believes that the SRA should ensure that the EPF regime continues to be available to you to make this sort of work easy for you.
Chris, can I just interject here? And
yeah.
If the exempt professional firms regime is withdrawn,
yes,
the natural order of things when engaging with a client is that on some level you will, of course, have discussions with your client and not just act in an advisory capacity. You're just having a few discussions.
It's general chats.
General
really.
chats,
it's the type of chats that solicitors engage in with their clients, which are advisory.
Yeah. But, well, this is what my question is that, so is it not just the case that if Jane, for example, was to have a general discussion about her concerns, her clients' concerns about their financial situation in relation to loans, could she not just put a disclaimer or a clause into her terms of business to say that anything that we discuss in relation to finance will not be in an advisory capacity or will not be deemed as advice, and that would therefore cover her? Is that possible, do you think?
Well, it's a very good question, and it's something which Jane should consider. I think the issue that she may run into is as follows. She must act in her client's best interests, and she must treat her clients fairly. Is it possible to exclude to a divorce client under financial pressure any discussion about financial matters from the scope of the retainer? Could that clause be fairly inserted into the firm's terms of business? It may be possible. I don't have a definitive answer to that, but she needs to think that through very carefully.
So the SRA's proposals to remove the exempt professionals firm regime will, how then do you foresee that, without that in place, without that security in place, how do you see that? What would you think will be the alternatives that the profession will have to look to? I mean, for example, we just mentioned there one possibility of inserting clauses.
I mean, there are only two alternatives available to Jane. Stop doing any consumer credit activity. So don't enter into regulated credit agreements with your clients. Don't provide any debt counselling, and don't provide any credit information services.
But by its very nature, that will come into any discussion that she has.
Okay, so she's either got to not have those discussions, or her firm have to obtain authorisation from the Financial Conduct Authority, and if they don't, they will be committing, and she will be committing, a criminal offence of breaching the general prohibition. She will be providing financial services when she is not authorised to do so. And it's a criminal offence.
Just by having those discussions?
Just by having those discussions.
In general chit-chat on that sort of level, you believe that would be the case?
Yes, that's my interpretation of the...
I think the concern would be that with an increasingly competitive market as it is, many solicitors, of course, will try to get the edge over one of their peers, and perhaps they will be able to offer that service to the client. So if she says, I won't be able to offer it, the answer is simple: go elsewhere. She's going to lose business, isn't she? And if she can't provide that service, because the nature of a divorce matter will be to talk about personal finances.
She may well do. That's why I said she needs to carry out a proper risk assessment, and she needs to think, what are the commercial implications? If there are 4 firms in Jane's town and 3 of them have Financial Conduct Authority authorisation and she doesn't, is that an issue? I don't know. I'm not a family lawyer. I don't know how important those discussions are. I don't know to what extent clients look to Jane for that sort of advice. I don't know how much it would hurt Jane if Jane just said, I can't talk to you about that. Maybe it's not an issue. But what Jane has to understand is what is and what is not consumer credit activity, and to what extent is it important that I'm able to continue to provide consumer credit activities. And she really needs to be thinking that through right now.
And do we anticipate any guidance coming forth from the SRA once this is, if they do, have they given any indication that they will provide some guidance if they do withdraw the exempt professional firms regime?
I mean, the SRA almost certainly will have to publish lots of guidance in that scenario. I think that the SRA has not worked out the full implications of withdrawing the EPF regime. I mean, I don't know anything about Jane's firm, but perhaps Jane also has colleagues who, for example, deal with conveyancing or litigation, and who in the course of their work issue indemnity insurance policies or after the event insurance policies. Because if Jane decides that she has to seek FCA authorisation for her work, then her colleagues cannot continue to use the EPF regime for their work, because you cannot be an exempt professional firm and an authorised firm at the same time. It's not possible. So the issues may in fact go beyond Jane's department and start to have an adverse impact in regulatory terms on the rest of the firm. Okay.
Just moving on now then, I've got another email here from Bill. He's a personal injury lawyer, and the question from Bill says, I'm sure that this doesn't affect me, but we do get involved in credit hire work. Do I need to be concerned?
Okay, the short answer I think is no.
For anyone watching, by the way, who may not be familiar with what we're talking, I mean, those of you involved in personal injury will, but just explain what we mean by a credit hire work for all of our viewers.
Okay, it's quite simply when you're acting for a client who's been injured in a road traffic accident, and as part of the service that you provide, that client goes to a car hire company, and the cost of the hire vehicle is reclaimed from the third-party insurer.
Okay.
Now, there is a slight danger here, and there is a trap that you could fall into. It's as follows. It's back to credit broking, because if Bill affects an introduction of a client to a credit hire company, then he may be credit broking. First of all, he will only be credit broking if he affects that introduction before proceedings have been issued, which, on my understanding, would normally be the case. You wouldn't normally want to wait until proceedings have been issued before providing a vehicle for your client. That's because post-issue work is covered by an exemption, solicitors acting in the course of contentious business. So where Bill may have a problem is if pre-issue he affects an introduction of a client to a credit hire company. Now, what Bill will also be aware of is the historic costs cases, and one of the leading cases is going to be relevant. This is Dimmond and Lovell, which Bill will know about. And
so what's that case?
Dimmond and Lovell.
Dimmond and Lovell.
I don't have the full citation. I think it's 2002. I don't need to go into that case in detail. What Bill needs to be aware of, though, is that post Dimmond and Lovell, most credit hire agreements have deliberately been drafted so as to be exempt from the consumer credit regulation. So, in fact, in the usual normal course of events, if Bill sends a client, even pre-issue, to a credit hire company, that client will not be going there to get a consumer credit agreement. They'll be going there for an exempt agreement. But the complication is this. That means that Bill is relying upon the credit hire company concerned to have drafted their agreements correctly. And Bill will unfortunately need to check all of those agreements and keep checking them every time they change and make sure that they are in fact drafted in such a way as to qualify for an exemption from the consumer credit rules. So it's just, every practice area that we look at, we see little sort of traps that you could fall into, ways in which you could inadvertently become involved in carrying on consumer credit activity, and that's just an example. I mean, the other issue that Bill may have is this. We've advised a lot of personal injury firms for a long time, and something that happens, not regularly, but it certainly does happen. Now, there won't be, I suspect, any personal injury lawyers out there who aren't familiar with this scenario. And this is where your own client becomes liable to pay your costs. So they've breached the terms of the CFA. They've usually done something, either complete failure to engage with the process or something even perhaps dishonest. And you, as a solicitor, want to be paid by your client. And you're entitled to be paid by your client under the terms of your retainer. So let's just say, for example, your client owes you £6,000. What Bill will need in that scenario, I suspect, is the freedom to enter into a financial accommodation with that client and to say to that client, okay, you don't have to pay me £6,000 today because I accept that you haven't got it. But you do have to pay me £500 a month for the next year. And in that case, of course, Bill will be entering into a regulated credit agreement with his client. Now, again, all of this stuff is fine if Bill has the benefit of the exempt professional firm regime. He can do all of this stuff under that regime. All he has to do is ensure that when he does it, he complies with the SRA Financial Services Scope Rules, the SRA Financial Services Conduct of Business Rules, and of course, under Rule 5.11 of the Scope Rules, that he complies with the provisions and guidance contained in the Financial Conduct Authority's Consumer Credit Handbook. You might want to replay that bit. But provided he does those things, he can continue under the EPF regime to do all of those things without an issue. If, however, the SRA withdraws the EPF regime, then he cannot do any of those things without Financial Conduct Authority authorisation. So just by saying to that client who owes him £6,000, OK, pay me back over a year, Bill will be carrying on consumer credit activity, and if the EPF regime is not available, Bill will be committing a criminal offence if his firm's not FCA authorised.
So just to be clear, and again, just to remind ourselves from what we discussed last week, we're talking about dual regulation here. We're talking about the possibility, as of after this December, the possibility, we're not talking about it actually happening yet, but there is a
well, it's what the SRA wants. That's what we know.
It's so what the SRA is proposing is that the profession will be duly regulated by the Financial Conduct Authority and the SRA, so double whammy. I think I just want to...
Sorry, but could I just make a point on this issue of the SRA's consultation? What normally happens when the SRA enters into a consultation process is that there are a bunch of usual suspects who respond, usually very large, well-resourced, organised firms. Lots of city firms, lots of international firms, even national firms, who have large compliance departments, who have lots of resource, and they're able to make these responses. The Law Society will routinely respond as well, to the extent to which the SRA takes notice of the Law Society's representations is very debatable. However, what I fear will happen in this case is that these large firms, most of which are already Financial Conduct Authority authorised, will respond and will say, this is not a problem, this is fine, we agree. So we may well end up with the SRA with 30 responses, 28 of which say, yeah, it's fine, and it'll justify their decision. Please, small firms out there, take the time and effort to respond. Let's get 500 responses in, which all say this is not fine, this is a big problem for us. This is going to cost us a lot of money. This is going to hurt us. This is going to hurt our clients. This is not in the interests of consumers. It's not in the interests of the legal profession. This is the SRA acting in its own interest. And if we get those 500 responses in by the 15th of December, the SRA cannot possibly press on.
Can you just remind everyone watching the reasons behind the SRA's proposals to withdraw the exempt professional firms regime? Because obviously I know we discussed that in some detail last week, but I think it's worth just revisiting these points, because why is the big question. Why are they withdrawing this, or why are they proposing to withdraw it?
Okay, the SRA has two valid reasons for not wanting to be a designated professional body, and one reason which I think is questionable. The two valid reasons are, first of all, they don't believe a lot of law firms will be able to pass the complementary test in relation to a lot of work. I agree. The second is they don't think it would be appropriate for lawyers to have to comply with the entire provisions of CONC, the Financial Conduct Authority's handbook, in relation to the very limited consumer credit activity they carry out.
CONC standing for Consumer Credit Handbook.
I agree. The third reason I'm not sure about, the SRA doesn't want to have to train its own people and recalibrate its own model and develop the expertise required to regulate this activity. The SRA is not reluctant to impose heavy regulatory burdens on others, which often include recalibration of models, upskilling, training of people. I think, given how blasé the SRA are when it comes to imposing those obligations on others, I think the SRA ought to man up and accept its responsibility and deal with that. It's not, in my view, a good argument that they lack the budget or resources. Their budget is, in fact, very generous.
Okay. Thanks for that, Chris. Thanks for clearing that up. Okay, another email now. Now, this is in relation to conveyancing, and we had rather a few emails in relation to this, and I hand-picked this one because I thought this was pretty much the best one to highlight the concerns. This is from Zena. Zena, if you're watching, hello. And Zena says, the question is, I am a conveyancer. Do I need to worry? It's that simple.
Well, hello, Zena. I'm not sure that you do. I think you will be carrying out occasionally consumer credit activities without realising it. For example, let me just give you a random example. If you're sat with a client and that client says, when I get this mortgage through, is it possible that I can use some of the funds to repay this unsecured credit that I've got? Then and you advise on that, then that's debt counselling. If your client just says to you, I'm thinking of applying for a mortgage, but I don't know if I'll get one, and you just say to your client, well, go and do a credit search on yourself, again, that is consumer credit activity. So Zena, I think you will do some consumer credit activity.
What, even just saying go and do a credit search on yourself?
Yeah.
Just go on, do a credit search on yourself.
Yeah.
That
would you like chapter and verse on that?
No, but I'll take your word for that.
Well, Zena, just in case you're doubting me, I will give you chapter and verse on that. If you go to Article 89A, 1, 89A1 says, taking any steps on behalf of an individual to do the following things would be providing credit information services. One of the things on the list at 89A3A is ascertaining whether a credit information agency holds information relevant to the financial standing. So you will say, well, I'm not doing that directly, I'm just advising the client to do that. But if you look at 89A2, it says giving advice to any individual as to how to go about any of these things. So simply just saying, go online and do a credit search is caught. So Zena will carry out some consumer credit activity. Zena will also carry out some insurance mediation activity when she issues title indemnity policies, for example. And that's not a problem for Zena, and neither will this be a problem for Zena, provided that the exempt professional firm regime continues.
Which we don't believe it will.
Which we don't know, which we hope it will, and we're going to argue that it will. And LBS Legal will certainly be making representations to that effect, and we're urging everybody else to do likewise. Zena, if the EPF regime is withdrawn from you, not only will you have to carry out this consumer credit activity in full compliance with the FCA requirements, because you'll need to be authorised, but your insurance mediation activity will also have to be carried out to the same standards that insurance brokers operate. So it won't be a quick, easy, light regime in relation to that. You'll have to tick all the boxes that any insurance broker would have to tick. If there is an upside, it's that you can get a little bit of commission for issuing those policies.
Okay, just being aware of time, because we've got a lot to move through. Same question, high value contentious probate. Should they worry?
Well, some of the things that I've said already will be relevant, so I'm going to try not to repeat those. But something that did catch my eye the other day, which may be relevant to your contentious probate lawyer, whose name you haven't given me.
Well, Linda was the
although
person
I suspect all these names are made up anyway.
No, no, Linda.
So Linda, hi Linda. Perhaps you are getting involved in third-party funding for your contentious probate work. Litigation funding is expanding in several areas. Companies like Novitas, which provide consumer credit facilities to clients in order to pay their legal fees, and then they pay those legal fees directly to the law firms. The areas where I see this kind of activity: medical negligence, disbursements funding, contentious probate, employment law, family law. So what I would be concerned about perhaps is that if Linda,
yes,
is saying to clients who can't afford to pay her, go and talk to Novitas, then she's credit brokering. Again, credit brokering is fine if she's able to do it under the exempt professional firm regime. And I'm sorry to be repetitive, but you can see the withdrawal of the exempt professional firm regime will hurt all sorts of lawyers in all sorts of practice areas. It is, in my view, imperative that this EPF regime survives.
Okay. Another email here from Tristan. And Tristan writes, we think that we're in a very difficult situation. I am a partner in charge of a debt collection team, which accounts for 25% turnover of this firm. We're not FCA authorised, and we don't have transitional permission. What are the issues I need to cover? So very clear, that one.
Okay, well, hi Tristan. You
Did
may
you say
not...
Tristan? Tristan.
Tristan, sorry. Tristan, you, as a debt collection lawyer, are a person who may obviously feel in the firing line, more so than some of the other practice areas we've already mentioned. It may not be true to quite the extent that you fear. You undoubtedly will carry out some consumer credit activity. Debt collection is in itself a consumer credit activity. So let's be clear about that. But what people perhaps haven't understood is that there are a lot of exemptions, and a lot of the work that Tristan's department does, I suspect, may not be caught by this. What I'm going to try and do is something which I've not seen in any of the Law Society practice notes, Financial Conduct Authority guidance, SRA consultations and guidance. I'm going to try and take a systematic approach to the considerations that you need to have in your mind if you're a debt collection lawyer. So there are a number of different ways to do this. I've chosen to do it by starting with what is not caught by the changes. First of all, collecting debts from businesses is not caught or affected. So I don't know what the work this firm does is, but if you are chasing a commercial enterprise for money rather than an individual, you are not going to be caught. Unfortunately, like with all of these provisions, there's a bit more detail to it than that. If you look at Article 60b(3), it defines what is a credit agreement, and it means an agreement between an individual, okay, that's caught, or a relevant recipient of credit. Well, what is a relevant recipient of credit? Okay, that is defined in Article 60L, and you'll see that a relevant recipient of credit is a partnership with 2 or 3 partners. So if you're chasing a partnership of 4 partners, that's fine. If you're chasing a partnership of 2 or 3 partners, it's slightly more complicated. You have to continue looking through the various articles, and you'll end up with Article 60C. And in general terms, if that 2 to 3 partner practice took out some lending for wholly or predominantly for the purposes of their business, then you're fine. That's exempt. You can go ahead and go after them. If the 2 or 3 partners took out the finance wholly or predominantly for private purposes, for themselves, then that will be consumer credit and it will be caught. So subject to a little bit of careful consideration at the outset, collecting debts from businesses is not caught.
Right.
Okay, so that leaves collecting debts from individuals. Let's look at that. Well, first of all, any post-issue work is excluded. There's an exemption. If you're acting in the course of contentious business, then you are fine. You'll find that exemption in Article 39K. A solicitor acting in the course of contentious business will be exempt. Contentious business is the definition that we discussed last week, Section 87(1) of the Solicitors Act. Business done in or for the purposes of proceedings begun before a court. So the proceedings have to be begun. So, if Tristan takes his work, for example, from debt collection agencies who have already sent a letter before action, and if Tristan literally opens a file and first thing he does is issue proceedings, then that's fine, that's exempt. If, however, he gets the file a stage earlier than that and sends a letter before action, for example, then that will be caught. So post-issue work is fine. Forget about post-issue work. There's a slight grey area in relation to post-issue work. There's been a lot of argument about whether issuing a stat demand is pre or post-issue. I personally don't understand why there's been a lot of argument. A stat demand is not an originating document. It does not commence proceedings. Proceedings have not begun before a court, and in my view that is pre-issue work. And therefore, if you entered into, for example, any debt debt administration or the recalibration of the debt after issuing a stat demand, but before commencing proceedings, that would all be court. Okay, so collecting debts from businesses is not court. Post-issue work is not court. And don't forget that only certain types of debt are court. This is not any debt collection for anybody in relation to any type of agreement. This is debt collection of specific types of agreements. To be precise, it's debt collection of just 3 types of agreements. Number 1, a credit agreement. Number 2, a consumer hire agreement. Both of those agreements are defined in the statutory instrument and are pretty much what you would expect them to be. So I don't think I need to spend a lot of time on that. The third type of agreement, which is court, is an Article 36H agreement. So Tristan needs to look at Article 36H and figure out what Article 36H means. I'm going to do that now for Tristan's benefit.
You beat me to it.
Yeah. Article 36H.
We're all on the edge of our seats, Chris. Article 36H.
Subsection 4.
Ooh.
An Article 36H agreement is an agreement between one person, the borrower, and another person, the lender, by which the lender provides the borrower with credit within the meaning given by Article 60L. Right, let's continue the definition chase to Article 60L, and you'll see that credit includes a cash loan and any other form of financial accommodation. So where does that all leave us, right? What is an Article 36H agreement? I'm going to try and make it clear by way of an example. If a dentist issues a bill for £5,000 to a patient and the patient just doesn't pay, and the dentist says to Tristan, chase that debt for me, that is fine. That is not an Article 36H agreement. The dentist has not provided credit to the patient. The dentist has not made a cash loan to the patient, and the dentist has not made any other form of financial accommodation with the patient. It's just a bill for services that hasn't been paid. However, if the dentist had already been trying like mad to get the money from the patient and had spoken to the patient and said, okay, I'll give you 3 months to pay. Okay, I'll knock 5% off my bill. Okay, any kind of financial accommodation like that, which had ultimately failed, and then the matter goes to Tristan's department, well then that will be an Article 36H agreement, and it will be consumer credit activity if Tristan's doing pre-issue work on that file. It's not quite as straightforward as some people think. Some people are kind of drawing a line between, debts to banks and hire companies and debts for services and goods. And they think all debts relating to services and goods are exempt. They're not. If the supplier or provider has entered into a financial accommodation with the customer, then it will be an Article 36H agreement. And you mentioned earlier this possibility of using terms of business to protect yourself. I think it now becomes a sensible clause to enter into your terms of business that your client, or Tristan's client, will expressly highlight to him if he or if the client has already entered into any form of financial accommodation with the debtor. So therefore, by way of a standard documentation, Tristan is ensuring that all of the debts that he's acting on are not within the scope of these regulations because there has been no financial accommodation. And therefore he's entitled, I think, to accept those instructions, to accept that this is a straightforward non-payment of a bill, and he's going after the defaulting debtor. So that's another huge exemption. So where does that leave Tristan? Well, it means that quite a lot of what he does is not caught up with all of this stuff. But he needs to look carefully at pre-issue work that he does against individuals on behalf of clients for whom he doesn't do a lot of other work, or for whom his firm doesn't do a lot of other work. Because don't forget, I'm not saying that if it's pre-issue work against an individual and it is the correct sort of agreement and it is court, I'm not saying he can't do it. I'm saying he has to do it under the exempt professional firm regime, so that it has to be incidental to the work of the firm, and it has to be complementary or arise out of the services provided to that particular client. I think on a kind of audit of Tristan's department's work, he will find that 75 or 80% of what he does is not touched by this. It's the issue of the remaining 25%. There may even be a small percentage of that work which cannot be justified under the EPF regime, and therefore the only solution is that he stops doing it. And if that's going to be a big hit to Tristan's department, and if he can't function, if he can't be profitable, having stopped doing that small residual category of work, then his firm needs to go for Financial Conduct Authority authorisation.
Dual regulation.
Dual regulation.
Okay, thanks for that. Hope that helps, Tristan. And of course, I think in closing, as our clients, you'd probably be keen to know how we are going to continue to support you as this consultation period is played out. So we will be available to all of you with any queries that you might have in relation to this, and of course we will keep you abreast of any developments as they go. But if you do wish to contact us, you will already have our contact details, but of course you can go to www.lbslegal.co.uk and you'll see our contact details on there. So we will be keeping you informed as this consultation develops, and as I say, we're available for any of your queries going forward. So Chris, thank you again.
Thank you.
And detailed as always, and nothing left to really be concerned with. I think you've covered everything that I think most of our clients were really sort of like concerned about. And I'm just going to say concerned again, concerned. So thank you again for joining us today, and I hope you found it interesting. And we'll see you again shortly for another discussion. Thank you.